Hi, everybody. Bill Prince here. Welcome to our second week together in Introduction to the Law and Legal Reasoning. Thought we had a really good first week. Hopefully, you enjoyed that relatively non traditional question on cannibalism. And the Dudley and Stevens case, but I do think it's a sort of a good way to whet your appetite, so to speak, for some of the issues that courts have historically faced and continue to face in making decisions, and looking into what goes into those decisions, the law, personal bias, community standards, all of that kind of thing. So hopefully you enjoyed that discussion. I thought we had some really good discussion. I was well pleased with the quality and the quantity of posts. So keep up the good work, and we'll have a great 8 weeks together. Make sure that you complete the week 1 assignment and get your courts in the news posted as well, so that I can get those graded for you. In week 2, which covers June the 11th through June the 17th, we're going to be looking at a couple of general topics and a number of specific subtopics within. One, we're going to be looking at the structure of the federal and the state court systems and see exactly what the architecture of those systems are. That, of course, is the institution in which the judicial process occurs. And then in the second part of the week, we're going to be talking about legal reasoning, and we got into that a little bit last week in looking at the Dudley and Stevens case and some of the conversations that we had, but we're going to get into it in a little more formal manner this week. And so as such, a couple of highlights for you. First of all, with regard to our discussion question this week, I have posted a video which is about 15 minutes long. This comes from 60 Minutes a number of years ago, and it was a piece that was done on Justice Antonin Scalia, the late Supreme Court Justice, who was a very conservative Supreme Court Justice. And this piece sort of goes into judicial philosophies and interpretive styles and philosophies. In other words, the Constitution, which is the supreme law of our land, is words, and it's words that were written, well over 200 years ago by individuals who, didn't know about cars or electricity or cell phones or GPS or cloning or all of the number of other issues that seem to face the court today. And so the question about how the highest court in the land, which is the final arbiter of constitutional interpretation, how they decide cases is relatively important to understand. So watch the video, and it sort of highlights Justice Scalia and then his counterpart, Justice Ginsburg, who has an altogether totally different interpretive philosophy. So hopefully you'll enjoy that and having good discussion about that. Additionally, as I indicated in the announcements this week, we're actually going to start briefing some cases, and so when we go to the assignment, you'll see that there's at least 2 or 3 cases in there that you'll be required to brief. Now, briefing is as much an art as a science. It takes practice. I don't expect folks just to read a case and then be able to distill the issue and the holding and all that kind of stuff right off of the bat. So give it your best shot, and I will certainly take that into consideration in grading the assignment. The first case you ought to be familiar with, People versus Kevorkian. That deals with Jack Kevorkian, who was the fellow that was going around kind of helping people sort of transition to their great reward. So again, enjoy doing that. And then I have posted for you this week. Let me scroll down here a little bit. There we go. The Law Nerds piece on the Iraq, that's not Iraq like the country, but the Iraq formula for briefing cases and looking at legal analysis. Because one of the things that we're going to find in terms of talking about legal reasoning is, as we talked last week about this concept of precedent and stare decisis. And remember that precedent is the rule rule that is set forth by the court in a case. And if we're dealing with a Supreme Court case, all other lower courts, which would be every single court, they're required to follow that precedent. So precedent is the idea. That's the rule of a case. And stare decisis is the principle that indicates that courts, lower courts in particular court systems, are required to apply that precedent or apply the rule of the case in future cases where you have similar facts and circumstances. Now, of course, the job of lawyering and the legal profession is to try to convince the court that in any given case, particularly the one you're working on, that one, either the current precedent supports your client and in his or her position and needs to be upheld, or and this is where it gets sort of creative to be in law, how this case differs a little bit maybe from that last case where the precedent exists, and why. And so in doing that, one of the things that lawyers, paralegals, and judges do is they read a lot of cases, and they try to analyze each case, look for trends and things like that, either to support the precedent or show how maybe this case ought to be ruled on differently, and thus creating a new precedent. So one of the easiest ways to sort of go about legal reasoning from the get-go is following this IRAC formula, which is issue, rule, analysis, and conclusion. So this Law Nerds piece, and Law Nerds has been around for a long time, and there's all kinds of stuff that you can find online. But this is a great resource. It's not in a bound leather-clad law book, but I really think that it contains some pretty practical things to consider when engaging in the process of legal analysis. So, so when you're briefing cases, you're going to want to find out, you read the case and what are the facts and circumstances of every case. So many times cases hinge on particular facts. What was the rule for the issue? So in going through a case analysis, you're going to want to find out what is the precedent at this point in time? What is the governing rule that was in existence at the time that this fact situation came up? Then you want to do some analysis. Does the rule that exists apply to this new set of facts? Again, if you're trying to advocate for supporting that rule, you're going to say, well, yes, it certainly does. If you're going to be looking for a different outcome, then you're going to want to show how the facts really don't lend themselves to having that particular rule applied. And then you want to see how the court's holding might modify the rule of law. So when you look at the Kevorkian case, did the court follow the old precedent, or did their new ruling result in basically a different precedent? So spend some time poking around this site. Again, I think you're going to find out all kinds of good stuff and some good tips for briefing the cases that you're going to come into contact with this week. So again, good last week. Looking forward to this week. If you have any questions, comments, or concerns, please don't hesitate to contact me, and we will visit with you online. Have a great week. Take care.